Thank you guys for coming. I'm Julie from Senior Communities Guide. We're the ones that kind of took care of the food. The people that are speaking today are all on our Senior Resources Guide, so you guys are going to get this in there. What it is it has all the senior communities in Minnesota on it. It's about 2,000, from the large ones all the way up to the smaller ones. And then on the back is Resources Guide, which includes the people that are speaking and also other people too if you have other needs. So that will be in there. And first person up is Brian Stevens. He owns the law office of Brian E. Stevens. And he'll be talking about the legal things that you want to know about and think about as you're kind of moving into or thinking about moving into assisted living or down the road might need assisted living. So, go ahead, Brian.
Well, and I'm here to talk about estate planning. Estate planning is something that sounds intimidating. It's actually not that difficult a process to enter into and to complete. And my goal as an attorney is to make sure that my clients understand everything that they're doing and understand the choices they're making so that they feel confident in the estate plan that they've put together. And so today I'm just going to talk about the basics of estate planning so that you can have some idea of what you would want to consider if you haven't done your estate plan, or what you might want to consider if you need to redo your estate plan. Many people may have their estate plan done when they, for instance, when they first had kids, they had a will done and talked about guardianship and things like that. And as we age, those considerations are left behind, and there's other considerations that we face. So I'm going to talk about estate planning. I will take questions, but I'd ask you to kind of wait until I'm done, and I think there'll be enough time for some questions and so forth. So the first thing to know about estate planning is that it always involves more than one document. Some people think of an estate plan, they think, oh, I've got my will done, and so that's good. But there are some more other necessary documents. And a couple documents that are necessary when you're living are what's called a healthcare directive. Pardon my handwriting, I'm not that great at it. So a healthcare directive is a document where you appoint someone who can make medical decisions for you whenever you're unable to make your own decisions for yourself. And that can be a very crucial document to have. Another important document to have while you're living is a power of attorney. And with a power of attorney, you can appoint someone who can make medical decisions, that was the healthcare directive. You can appoint someone who can handle finances for you if you're unable to handle finances yourself. So both of these become very important documents, particularly later in life. My mother-in-law died a few years ago. She was 98 years old. She was in memory care, and she had quite significant dementia. And she had spent down all of her assets so that the state was paying for her nursing home costs. And so it didn't really matter what her will said because she didn't have much money. You're allowed to have $3,000. But what was far more important were the healthcare directives and the power of attorney, so that she was able to state who's going to take care of my business matters for me and who's going to make medical decisions for me. So very important documents to have in place, and that they're part and parcel of any estate plan. And then I'm going to move on to the documents that you would use for when you die. And I'll preface this by talking about two different kinds of assets. When people die, they'll have two broad categories of assets. One is called probate assets, and the other are non-probate assets. And it's easier to define what non-probate assets are, so I'm going to do that. But I want to let you know before we talk about non-probate assets, probate assets are governed by a will. And whether you know it or not, you have a will, even if you've never seen a lawyer and gotten a will put together, because the legislature wrote a will for you that applies if you die without your own will. So everyone in Minnesota has a will. The question is whether they had any say in what it says or not. But a will has jurisdiction over probate assets only. Non-probate assets pass in some manner besides the probate system. So a couple of these, I've got 3 of them up here, but anything that's owned in joint tenancy. So my wife and I own our house as joint tenants. And that means if I were to die, then it doesn't matter if I have a will, doesn't matter what the will says. The joint tenancy laws say that my interest in the house passes to my wife. Okay, so a house that is owned by 2 people, if it's held in joint tenancy, that will not have to go through probate when the first person dies. Okay? However, after that first person dies, then it's no longer held in joint tenancy. So the house would then come over here and would become a probate asset upon the death of the second to die. So joint tenancy, one of the biggest types of non-probate asset. The second one is anything that's governed by a beneficiary form. So if you have life insurance, you fill out a beneficiary form. If you have investment accounts, you fill out a beneficiary form if you're a financial person. And again, it doesn't matter if you have a will, it doesn't matter what the will says. The beneficiary form is a contract, it's part of your contract with that life insurance company or with that financial company, and that supersedes anything that you have written down over here, okay? And then the third major form of non-probate asset is anything that is held in trust. And you may have heard of living trusts or revocable trusts. And that's what I'm talking about when I use this word trust here. There are a whole slew of types of different trusts. But what I'm talking about specifically is a revocable living trust. It's a trust that can be amended. It's a trust that can be revoked if needed. It's a very flexible planning tool. And what this trust does is it mimics what a will does. It looks like a will, smells like a will, talks like a will, but it's not a will. And the nice thing is, the huge difference between a trust and a will is that a trust can own property. A will comes into effect after you've died. But when you create a trust while you are living, you can put your assets into that trust and they won't have to go through probate. Okay? Now, kind of the kicker to all of this is there's a misconception out there, and there are people who think that if they have a will, their estate won't go to probate. And that is a misconception. A will does nothing to avoid probate. What a will is kind of a set of instructions to the court saying, here's how I want to wrap up my estate and file my final tax returns and pay my creditors off, collect up all my assets and liquidate them and get them to the people that I name in the will. Okay, so this will doesn't do anything to avoid the probate process. And if any of you have ever been involved in a probate process, you may know that it takes a long time. It takes usually 8 to 20 months. The depending on the depending on the complexity of it, it'll take a good year usually. And frequently, it's gonna cost between $5,000 and $15,000 in court costs and attorney's fees. And the reality is that it's not you that has to lay out that money, or it's not you that has to spend that time and deal with the mess that a probate is, but it's your next of kin, it's your children, or if you don't have children, then nephews or nieces, or whomever you're leaving your assets to. Whomever you've named as your personal representative or your executor, they're the ones that are gonna have to deal with all of this. And so what a lot of people do as they approach retirement or after retirement, they will create a trust. They'll create this revocable living trust. And what we do when I create one of these for my clients, it's kind of like I'm building a great big fence around a farmyard. And my job is to build the fence and then to help my clients get their animals inside the fence. So we want to get your assets into the trust. So we take your house, and instead of letting it go through probate, we put the house into the trust. And if you have a cabin, we put the cabin into the trust. We take your bank accounts and we put them into the trust. If you have investment, if you have after-tax investments, we put those into the trust as well. We take virtually any kind of asset that could end up over here and we put it into the trust so that upon your death, there is no need for a probate. And that's why you probably get mailings from law firms saying, hey, come on out, we're gonna have a seminar talking about estate planning. I'm giving you, a 15 or 20 minute version of what they would usually spend 45 minutes talking about. But this trust becomes a very streamlined way to handle an estate. Because you name a backup trustee, and that backup trustee, kind of like an executor, that backup trustee can start to act, but they don't have to get appointed by the court like an executor does. They can start acting right away. They can start acting, the week after you've died, they can go and start taking care of bank accounts and start taking care of if there's house payments or if there's other debts that are coming due and so forth. So that's the backup trustee. Yep. So this becomes a very flexible and very convenient way to do estate planning. So what I do with a lot of people who are retirement age and older is that I build this trust for them. We still do a will. It's called a pour-over will. And that's in case some asset gets forgotten and it didn't get into the trust. So we have a will that says if we forgot something, then put it into the trust. So it's really a will that's designed not to be used. But we still do that. And then we do healthcare directive and power of attorney, and we do the quitclaim deeds to get your real estate into the trust and so forth. And that becomes probably the most attractive and useful form of estate planning for people who are in their 60s, 70s, 80s. So, do you have any questions? Yes?
Are there any concerns or indications about when you put property in that trust? Is there limitations or is there?
There's no limitations to what you can put in the trust.
No, but as to the people that own it, can they do whatever with it or?
Yeah. Because what we do is the people that are creating the trust, they're gonna be the trustees while they're living.
Okay.
And they're also the beneficiaries while they're living. And so they can do whatever they want with their assets.
There's no limitations.
No limitations. So if you put your house into the trust and later on you sell your house, there is no problem with that at all.
I see.
So, other questions? Yes?
Yeah, I've heard that it's a good idea to build in some kind of payment or reimbursement for the person who's at least your power of attorney, like so much an hour, so that once you die and they have to take care of all this stuff, that you build in some kind of reimbursement for them for all the work they're doing.
Right.
Have you seen that, or what do you?
Absolutely, yeah.
What do you recommend?
I typically recommend, I don't recommend that you put in a specific dollar amount because we don't know exactly how difficult things will be. And we also don't know when that power of attorney might be needed. So if I put in my estate plan that, I wanna see that my backup trustee, the person who's gonna be acting after I die and my wife dies, if I say I want them to get paid, $30 an hour, well, it could be 40 years from now. And, $30 an hour might be, incredibly little. So I don't typically recommend putting a specific dollar amount in. What I do recommend, and what I always do, is I put a clause in saying that that they are allowed to hire agents, so they can get an attorney, they can get an accountant, they can get financial counsel from people. So we make that plain, and then we also make plain that they're entitled to reasonable compensation. And usually I'll temper that by saying, reasonable based on the type of work involved. So, does that help?
And who determines what's reasonable at the time?
There isn't anyone who necessarily determines what would be reasonable. If there were an objection to it, then the beneficiaries could bring suit. If somebody's taking $1,000 an hour just to write bills to pay, the light bills or, whatever. So, yes,
What about an IRA? Where does that fit in?
great question. So an IRA, you don't transfer that into the trust, because if you transfer it into the trust, then you pay all the tax right then. You pay all the tax right then. So on IRAs, we use the beneficiary form on the IRA to point the assets to the trust. So that the assets will flow through the trust after the person dies. So those income taxes don't get paid right away. If you move the IRA into the trust, then all of the income taxes are due right then. So that's not a favored way to do things.
You don't put IRA in a trust.
Correct. Right, you got a question?
Well, in regard your answer on that, so then, I'm not quite sure I follow you, how that benefit works. I mean, obviously it's at this place, so then all of the people that are benefiting by the trust have to split up the IRA's payments out, or it's,
Yeah, they would.
do that on their own after the death?
Yeah, they would get beneficiary IRA accounts.
Well, my other question was about how, on homes or cabins, is there a way to avoid capital gains to the beneficiaries? And
The way to avoid capital gains is, so transferring them to the trust does not avoid capital gains, okay? The only way to avoid capital gains is to allow them to go through probate. Because if they transfer upon the death of a person, then the person has what's called the stepped up basis. So they wouldn't owe capital gains on the value of the asset at the time of the person's death.
Say that again, please.
Okay, so. Draw a hypothetical, let's say I bought my house for $100,000. And it matures in value over the course of time, and when I die, it's worth $250,000. If I were to sell it, theoretically, I'd owe capital gains on $150,000. I mean, you don't, let's say it's a different asset, not your
Say
own.
it's $1 million.
Okay. All right, we'll do that. Say it's $1 million. So it's above the exemption that you get. So if I were to sell it, I gotta pay capital gains on a chunk of that. If it transfers upon my death, then the people who are inheriting that, their basis for taxation is $1 million. So those capital gains that I would have otherwise had to pay get erased, they're gone.
If it's in the umbrella of a trust.
Of the trust, because we're transferring into the trust while you're living, that rule doesn't apply.
Well, that's a pretty slick thing.
Yeah.
And a cabin likewise, I mean,
Yeah.
now that isn't subjected to,
You don't get the break, yeah.
but, well, I didn't have that understanding.
Yeah. So, other questions?
Did you want to talk about what is and is not a protected asset? I know that's something when going into assisted living, they talk a lot about that.
Sure. So protected assets. When somebody goes into a nursing home, and if they're going to be making application for the government to pay for the nursing home benefits, the government has a 5-year look-back period. So the government looks at what your financial dealings have been in the past 5 years. If there are any improper transactions, they will affect your eligibility for government financial assistance. And they will impose a penalty, and the penalty comes in the form of they will not pay for your nursing home benefits until the money that should have been paid to you gets paid by you for nursing home benefits. This is kind of a deep area to try and encapsulate in just a minute or two.
Sorry.
But basically, if there's a couple that owns a home and one of them is going into a care facility, the government does not ever force the non-institutionalized spouse to sell the house. That is not something they do. The government will put a lien on the house and seek to recover what they have paid after both spouses have died and the house gets sold. So that's usually the biggest asset that people ask questions about. And so the answer is the house is protected to a great degree. And even if a person is single, if they have somebody who lived in the house for 2 years and provided care for them, that person can continue to live in the house. So sometimes people will have a child who lives with them and is a caretaker for them, or a nephew or niece who does that. And that person can still live in the house, and the house does not have to be sold, so long as they live there for 2 years and provided that care for the spouse. So that's the biggest asset that I'll speak to. Non-protected assets, anything that you have in savings or retirement assets and so forth, those are going to be fair game that you're going to have to spend down. If you're married, there are different rules that apply because the non-institutionalized spouse has rights, so that it doesn't all get spent down. There's some pretty complicated formulas for figuring that out. Exactly what percentage does not have to be spent down. So.
What would be some simple examples of inappropriate spend down? I mean, can you give, what is it, $13,000 or $14,000 per person?
Yeah, it's 16,000 now.
16 now?
Yep, and
And
that
not
is,
inappropriate?
no, that is not inappropriate. So long as you can show that that is a pattern, you know, of giving that you've followed. Best example I can come up with is, you know, a father goes out and buys a brand new pickup truck and a nice boat, and then he's diagnosed with Alzheimer's, and he decides to sell it to his son for $5,000, and it's worth $90,000. Then the government's going to impose an $85,000 penalty and say we won't pay for the first $85,000 of care. So, all right, really quickly.
So like if you'd start giving, money to your grandchildren.
Yep.
Say, and you can give up to 16,000 a year. So then in, say, 3 years, you end up in a nursing home. Can they go back and get that money, claim that?
No, they can't.
They can. Thank you.
Just quickly, the last thing you were talking about. So were you saying that if you have a will, the basis of a house becomes what it is and that people don't have capital gains?
Right.
But if it's in a trust, they would? Is that,
It would,
they
because
okay.
that transfer happens while the people are living.
So that's a con?
That is a con.
Okay,
Yep.
okay.
Absolutely.